Good afternoon, everyone. I am Mary Beth Lewis, the Program Manager in South Jersey for the Alzheimer's Association Delaware Valley Chapter. With me today is our guest, Attorney Chris Bratton, founding member of Bratton Law, LLC, and chair of the firm's Trust, Estates, Elder Law, and Life Care Planning Division. Mr. Bratton counsels clients with regard to estate planning and administration, elder law, life care planning, asset protection, veterans benefits, and disability planning. Mr. Bratton is a member of the National Academy of Elder Law Attorneys and Life Care Planning Law Firms Association, is an accredited attorney with the Department of Veterans Affairs, and is past trustee and chair of the Young Lawyers Committee of the Camden County Bar Association. Mr. Bratton earned his BS degree cum laude from Southeastern Louisiana University, his JD degree from Rutgers University, and his LLM degree from Western New England School of Law. Mr. Bratton was named New Jersey Super Lawyers Magazine as a rising star for 2009, 10, and 12, by South Jersey Magazine as a top attorney in 2009 to 18, New Jersey Biz 40 and under 40 in 2010, and Awesome Attorney in 2010 to 19. Today, Chris will provide an overview of the 5 most important documents and the importance of having these documents in place. Before we begin, I want to remind you to please put your comments and questions in the comments, and Chris will address them along the way. Thank you, Chris, for your time today. Welcome.
Thanks, Mary Beth. I appreciate you having me on today. I appreciate that. Thanks to the Alzheimer's Association, all that you guys do for us. We love partnering with you. Today, the topic is your 5 most important documents. So we're going to kind of combine that with elder law as well. So it's going to be elder law, estate planning, and your 5 most important documents. And really, we can take this any way you want, because you are able, anyone that's listening is able to ask questions at any point. So I think we'll address those questions as we go, so that the conversation can go in any number of ways, as long as it's in the area of estate planning and elder law. So we're going to go ahead and get started. So here's some basic questions. What is estate planning? What is elder law? What is life care planning? And why the evolution along the way? Most people think when we're talking about estate planning, a lot of people think about wealth, and they feel like they have to have a lot of money for estate planning. And estate planning is not just about transferring wealth in an efficient manner, reducing taxes, things of that nature. It's also about incapacity planning. So what happens if you become incapacitated, if you can't make your own financial decisions, healthcare decisions? We need to have those documents in place as well. So we'll get to those documents in just a second. But what is elder law? What is life care planning? We're going to talk about all of that. So your basic documents are your will or living trust. Whether you go with a revocable living trust or a will really depends on your circumstances. It depends on the state in which you live, the probate with regard to that state. I would say in most cases, if you're in New Jersey, you're probably going to have a will, unless you have property in multiple states or you have an overriding desire to keep your affairs private, because once you probate a will, it becomes part of the public record. If you live in a state or have property in a state that has court supervised probate, then you may want to go with a revocable living trust in order to avoid probate, because in some states it can be very expensive, time consuming. Some states that have court supervised probate are, Florida, Texas, California, states like that. Your power of attorney is a basic document, your advance directive, your living will, the healthcare power of attorney, and your HIPAA release as well. So with regard to your will or the revocable living trust, some of the goals are to make sure you appoint or designate who's going to receive the assets when you pass, when they're going to receive those assets. So are we going to use some type of trust? So if a minor is going to receive an inheritance, we want to utilize a trust. If you have a child that potentially is a spendthrift, or maybe they have some kind of creditor problems, they have potential divorce issues, things of that nature, we may want to utilize a trust for that. Who's going to administer the will? So who's going to be the fiduciary, the executor or executrix under the will? If there's a trust in the will, who's going to be the trustee? Those types of things. Are you going to appoint your children as the fiduciaries or someone else? And then we want to take into consideration tax planning goals as well. So alternatives to wills. So a will is going to control any asset that is in your name alone. So if you own a house by yourself, your will would control that. If you own an investment account that does not have a POD designation, if you own a checking account, a savings account, your will is going to control those things. Some things that your will does not control, anything you own jointly with someone else. So if you own a piece of real estate that's joint tenants with rights to survivorship or tenants by the entirety if you're married, the will is not going to control that. If you have an investment account that's designated as POD or TOD, which is pay on death or transfer on death, the will is not going to control that because the designation form does that. If you have an IRA or a life insurance policy where there's a beneficiary designation, your will is not going to control that. That designation is going to control. So that passes outside of probate. So anything that you own on your own that doesn't have a designation is going to go through probate and your will is going to control. I think we're all aware now New Jersey has repealed their estate tax. They still have a New Jersey inheritance tax, but the estate tax is repealed. The federal government still has an estate tax, but it doesn't affect a lot of people these days. The federal exemption now is a little over $11.5 million. So what that means is if your estate does not exceed 11.58 million, then you're not going to have a federal estate tax issue. There is still an unlimited marital deduction, meaning anything that you're passing in between spouses, there's no tax on that if it's going to go to your spouse. And then I think we've all heard that you can give $15,000 per year per person, and you don't have to file a gift tax return or tell the IRS about it. Now, to the extent that you do give away that more than $15,000 per year per person, you have to file something called a 709, which is a federal gift tax return, telling the IRS that you gave away that money. But what happens is it comes off of your 11.58 exemption amount. So when should you review your documents? So we say usually every 5 to 10 years, take a look at your documents, or if there's been a death in the family, if there's been a divorce, if there's been a diagnosis of some kind or severe decline in health, you want to make sure that your documents are up to date. Periodically, you want to review them anyway, just because of changes in the law. But I would say in relation to any of these 5 Ds, you want to take a look at your documents and make sure that they're all up to date. So let's start off with the power of attorney. Now, what we're talking about here is a financial power of attorney. So you're appointing an agent under your power of attorney to handle your financial affairs in the event that you cannot handle your own, or you just choose not to handle your own, or you just need some assistance periodically in handling certain aspects. So we're talking about financial powers. It can come in one of 2 forms as it relates to whenever it's effective. So it can be an immediate power of attorney, or it can be a springing power of attorney. Immediate means as soon as you sign it, your agent can do whatever you can do, really with or without your knowledge, although they do have a fiduciary obligation to make sure that they're working in your best interest. Or you can have a springing power of attorney, which means it's not effective until 2 doctors certify that you're incapacitated, and then it becomes effective. You'll hear the term general durable power of attorney. General just means that it's broad in scope. Durable means that it survives incapacity, so that if you become incapacitated, it still continues on. You can have a special or limited power of attorney as well. So for instance, let's say that you're selling a piece of real estate, but you're not in town. Your power of attorney can do that for you. So you can give someone the ability to sell that piece of real estate, and the power of attorney is no longer in effect after that piece of real estate is sold. You want to look for some specific language within the power of attorney as well. If you're going to allow your power of attorney to engage in any type of gifting, that gifting language needs to be in the power of attorney. If you're going to give the agent the ability to gift to themselves, that specific language also has to be in the power of attorney pursuant to New Jersey statute. With a power of attorney, you can have co-agents, so you can have multiple people acting. It's always a good idea to at least have an alternate agent. So even if you appoint someone that's primary, you should also always have an alternate agent in place just in case something happens to that primary agent. But you can have co-agents, and you can make it so that either they have to act in concert or they can act independently of each other. That's going to be your choice. Now, what about your healthcare documents? Normally, what you'll hear is an advance directive, and that's really more of an umbrella term. It can encompass a healthcare power of attorney and a living will. So you're going to have a proxy directive and you're going to have an instructive directive. Your proxy directive is your healthcare power of attorney. Your instructive directive is your living will. So with regard to your healthcare power of attorney, you're appointing someone to make healthcare decisions on your behalf if you cannot make your own healthcare decisions. Now, with regard to a healthcare power of attorney in New Jersey, the financial power of attorney specifically points to the ability to have co-agents under New Jersey statute. The healthcare power of attorney doesn't specifically state that you can have co-agents under a healthcare power of attorney. What it says is that you should appoint a primary agent and an alternate agent. And, in my opinion, this is good because you don't want to have two agents not agree in a crisis situation with regard to your healthcare. If you're in a hospital or something along those lines, you want one person to be able to make that decision. Now, you may want them to consult with other individuals in your family, but at some point, we want to make sure that only one person has that final decision-making power. Now, your living will, that's setting forth what you want if you're in a permanent vegetative state or near irreversible coma. So if the doctors state that there is no hope for recovery, New Jersey statute defines a terminal illness as with regard to the physician's prognosis of 6 months or less with or without healthcare intervention, then that's considered a terminal illness. And then your living will is going to kick in, and your wishes are going to be known with regard to, do you want artificial life support, vent, mechanical respiration, feeding tube, artificial hydration, those types of things. Now, ultimately, who's going to decide whether you can make a decision or not with regard to your healthcare? And typically, it will come down to your physician. The physician will make a decision as to whether you are making good choices with regard to your healthcare, whether that physician is going to continue to listen to what you want, or maybe is going to turn to the healthcare power of attorney. Now, we're not talking about competency as it relates to a guardianship. We're just talking about the physician ultimately deciding who to take instruction from with regard to your healthcare. Now, certainly, if you have capacity, you should be able to make your own healthcare decisions no matter what. And everybody's heard of the HIPAA release as well, Health Insurance Portability and Accountability Act. This should definitely be included in your estate planning documents. I do see some practitioners include HIPAA language within the healthcare power of attorney. However, if there's only one agent named under that healthcare power of attorney, then only that agent has the ability to access your protected healthcare information. But there may be instances where you want other people to have access to that protected healthcare information as well. So if you have multiple children and one child is your healthcare power of attorney, but you want all of the children to be able to access your healthcare information, talk to the doctors and the nurses and find out what's going on, then you want a HIPAA authorization that names all of them. Now, all of them, they all don't get to make decisions simply because they're on the HIPAA authorization. Only that healthcare power of attorney is going to get to make the decision, but perhaps you want all of them to at least have access to the information. Now, what happens if you have not planned ahead, you kept putting it on the back burner, you didn't get your estate planning documents done, and now you're incapacitated? So if you don't have the requisite capacity to sign a power of attorney because you don't understand it, or you don't have the requisite capacity to sign a will, healthcare power of attorney, living will, those types of things, then someone is going to have to petition the court for a guardianship. Now, guardianship is a court proceeding. It's ultimately going to be decided by the judge. The proposed guardian is asking the court to appoint them as guardian over the alleged incapacitated person so that they can access their finances, they can make healthcare decisions for them, so essentially they can make all of their decisions. So this is in a situation where you're not able to execute your documents anymore. The way that this works is that we have to petition the court. We have to file an order to show cause of complaint, certification relating to property and income. The court is going to appoint an attorney to represent the alleged incapacitated person. Make sure you're not taking advantage of that person. That court-appointed attorney is going to interview the alleged incapacitated person. They are going to interview family members. They're going to interview the individual that's seeking the guardianship, and then they're going to report back to the court in written form and make their recommendations. And what the court wants ultimately is the least restrictive means possible. So if the alleged incapacitated person can participate at all in any decision-making, then the court's going to want to allow them to do that. Now, if they can't, then it's going to be a general guardianship, and the guardian is going to have full control over healthcare and finances. Now, if the person can participate in some manner, then the judge is going to carve that out in the order. So can they make a decision with where they live, or who they associate with, or things of that nature? Now, we often hear about trust, whether that be revocable or irrevocable. There's tons of different types of trust, and sometimes we have clients come in and they say that they want to trust. Well, when we start kind of digging down a little bit as to why they want to trust, a lot of times it's because their neighbor has a trust, or a friend has a trust, or a family member has a trust. Well, it depends on what kind of trust. It depends on what your goals are. Is it going to be a revocable trust? Is it going to be an irrevocable trust? What are you trying to accomplish? So there's tons of different types of trust for different purposes. But for tax purposes, and again, you want to make sure you go into an attorney that understands the tax aspect of this. For trust, for income purposes, for trusts, there's three types: grantor, simple, and complex. So we'll start with simple. Simple, there's going to be language in there that says the income shall be distributed out to the beneficiary. So in that instance, you can guess who's going to be taxed on the income. The beneficiary is going to be taxed. In a complex trust, you're going to see language in there where the income may be distributed out to the beneficiary. Now, if it is distributed out to the beneficiary, then the beneficiary is taxed on the income. If it's not distributed and it's instead accumulated in the trust, then it's going to be taxed at trust rates. So we won't get into the history of this, but income tax rates, for an individual person to reach the highest income tax bracket, you have to be a little over $500,000 in income per year. But for a trust to reach that highest tax bracket, it's a little under $13,000 per year. So you get to that highest tax bracket much faster in a trust than you do as an individual. So we have to be careful on how we draft some of these trusts. And then the third type is called a grantor trust. We use these a lot for many different purposes, whether it's asset protection or tax reduction or what have you. But here, all of the income that's generated in the trust goes back on the grantor's tax return, so that it stays taxed at the grantor's rate. So if the grantor is in a lower tax bracket, which typically is the case, then we're going to maintain that same tax advantage rather than having it taxed at a trust rate instead. So again, you may have a lot of different types of trust inside your will or as part of your revocable living trust. We won't really get into these very much because there's so many types. Lifetime gifting. So what if you want to give money away to the kids or grandkids? What is a gift? So if you're giving away something, you're receiving less than fair market value back. So if you give away $100,000, you've given away $100,000, all right? That's pretty easy. If you give away a house that's worth $250,000, then you've given away $250,000 as it relates to your gifting limit, right? If you sell a house that's worth $250,000 for $50,000, then you've given away that $200,000 difference there. So there's something called a unified credit equivalent amount. So your gifting amount is tied to your federal estate tax exclusion. So if you're gifting away money, you're allowed to give away up to your exemption amount. You don't have to pay taxes until you exceed that amount. And your annual amount, where you don't have to tell the IRS at all, is the $15,000 per year that we talked about previously. We also want to make sure that we're not confusing Medicaid regulations with IRS regulations. So for IRS purposes, we've already talked about the $15,000 per year. It's excluded. We don't have to tell the IRS about it. We don't have to file any forms. But for Medicaid purposes, that's going to be considered a gift. So whether you're gifting cash or whether you're gifting real estate, or whether you're paying someone's college tuition, or you gave money for a grandchild's wedding, whatever the case may be, that's going to be considered a gift for Medicaid purposes. Medicaid has a 5-year look back. Any gifts made during that 5-year look back could result in a penalty for Medicaid purposes if you're seeking Medicaid in the future. So we have to be careful with regard to making gifts. And you also need to be careful with doing things that you don't consider to be a gift, but Medicaid would consider it to be a gift. So let's say that you're living with your daughter and you're paying your daughter $1,000 a month to help her offset her expenses, food, electricity, gas, things of that nature. If you do not have a lease agreement in place, that $1,000 a month is going to be considered a gift for Medicaid purposes, and it could come back and bite you for penalty purposes if you ever apply for Medicaid during that 5-year period. So let's talk about asset protection and Medicaid. So we did talk about a grantor trust before, and I did mention that we utilize it quite a bit in protecting assets and tax reduction. One of the things we would prefer to do, again, if we're going to make gifts in order to protect assets, is we want to transfer assets to a grantor trust rather than to that individual directly. So if we have multiple children, we would rather transfer assets to a trust rather than to the children directly for a number of reasons. The children may be irresponsible, or even if they're not irresponsible, things happen. They could get a divorce. They may have credit issues. They may file for bankruptcy. They may pass away. There was an instance where a lady came to us. Prior to coming to us, she went to another attorney. That attorney transferred her house to her son directly, didn't use a trust. She didn't retain a life estate. And the son passed away. And his will said he left everything to his spouse. I guess mom and daughter-in-law didn't have a great relationship. Now the daughter-in-law owns the house because there was no life estate retention and it wasn't in a trust. The daughter-in-law kicked out mom and took the house. So again, that's one example of why we don't want to do that. If it's in trust, at least we still have control over it, right? We already talked about income taxation of a grantor trust. We can structure the trust so that either there's going to be a carryover basis or there's going to be a step up in basis on assets. So in general, what that means is if you're purchasing an appreciating asset like a stock or a piece of real estate, what you purchase it at, that's your cost basis. If you give it to someone, they take your cost basis. So let's say that you buy a piece of property that's worth $100,000. That's your cost basis. If you give it to your child, now their cost basis is $100,000. But let's say when you pass away, it's worth $250,000. Now, if the child then sells it, they're going to have a capital gains tax of $150,000 if it's not their primary residence, right? So the difference between the $250,000 and $100,000 is that built-in capital gain. So that's carryover basis. Now, if you were to allow that property to flow through your estate, then your child gets a step up in basis, so that your child's new basis when you pass away is now fair market value of the asset when you pass. So in our example, it was $250,000. So then if the child then turns around and sells it, there's no gain, there's no tax. Well, we can create a trust that does the same thing. Either we want it to be a carryover basis, or we want the children to get a step up in basis on appreciating assets. So we can do it either way, depending on what's most advantageous from a tax perspective. So that's something that we have to look at as well. Again, we talked about funding it with a house. You can fund it with stock, those types of things. But again, one of the important things to do is make sure that you're weighing the difference between the capital gains tax. Maybe New Jersey inheritance tax is going to play a role in that, but it all needs to be taken a look at. Now let's talk about Medicaid. So everybody is familiar with Medicare. You're entitled to Medicare if you paid into the system. But Medicaid is a needs-based program. You have to be age 65 or older, or disabled or blind, and you have to meet certain asset and income limits. So income is different than an asset. So an asset is anything that you own. Income is what you have coming in from Social Security, pension, technically any dividends, things of that nature, interest, also considered income. But once you're applying for Medicaid, then that's really going to be out the window, because you're not going to have much by way of assets. So you really, for Medicaid purposes, you're really looking at Social Security, pension, those types of things. If you have to go into a skilled setting, if you're on Medicaid, you get $50 a month. If you're in assisted living, you're allowed to keep $116 per month. You're still allowed to pay your medical insurance from your income, but the rest of it goes to the facility as part of the cost share. If your income exceeds a certain limit, and for 2020, it's $2,349. If your income exceeds this, then you need something called a QIT, which is a qualified income trust. So if your gross income exceeds that, if you're going to go on Medicaid, you're going to need this in order to qualify for Medicaid. So that's a separate kind of trust that you may need as well. We're looking at income. If we're applying for Medicaid, we're looking at income of the individual only, not the spouse. The spouse's income is disregarded. For QIT purposes, it has to be irrevocable. There's certain requirements by the state. There has to be a trustee named. There's going to have to be a payback provision. The person can set it up themselves. The guardian, the power of attorney, can set it up, or income can be redirected to the facility if we're not worried about the QIT, or it could flow into the QIT and then back to the facility as well. But there's going to be a payback provision with regard to Medicaid. So there's really not going to be anything left in the trust, but if there is a little bit left in the trust, then it's subject to an estate for estate recovery for Medicaid purposes. So Medicaid, if you're seeking Medicaid in the future, it covers skilled care, assisted living, in-home care, and the rules are a little bit different depending on whether you're single or married. But as we discussed before, an asset is anything that you own, regardless of whether it's exempt or not exempt, it's still an asset. But some of the assets that you own are exempt assets, meaning they're not counted for Medicaid purposes. Prepaid funeral, burial plot, engagement ring, wedding ring, some personal effects. Life insurance. So this is a big one that people get tripped up on. If the face value of the life insurance is more than $1,500 total, then the cash value counts. And that's combined over all the life insurance policies, okay? Now we're talking about a whole life, because group and term, they don't have cash value, right? So we're just talking about whole life. So if the total face value is more than $1,500, then the cash value counts toward your $2,000 limit for Medicaid if you're single. Now, if it's below $1,500, then the cash value is disregarded. So there are some policies out there. Maybe it's a $1,500 face value policy that has a $3,500 cash value because the person has had it for a while. $3,500 is more than $2,000 that you're allowed on your Medicaid limit, but it's disregarded because the face value doesn't exceed $1,500. Now, here's one thing that people will get confused about, and Medicaid may not be very helpful if you're filing a Medicaid application directly with the Medicaid office rather than going through an attorney. So let's say you have a $100,000 life insurance policy. So it has a $100,000 death benefit, but the cash value is only $20,000. Well, we know the $20,000 is going to go toward that $1,500 limit. So we can't have the policy. So if you go to apply straight to Medicaid, Medicaid's probably going to tell you you have to liquidate the policy. But if you liquidate the policy, you're going to get $20,000 and you're going to lose that $80,000 additional death benefit on a $100,000 policy. So perhaps the better thing to do may be to go and borrow against the $20,000 and then spend down that 20 as part of the Medicaid spend down and keep the policy in effect. And then that way you're still keeping that $80,000 death benefit as long as you have a named beneficiary on that account. So if you're married, all of these exemptions still apply, but the primary residence is also excluded. But again, one of the things we want to make sure we do is get that property transferred over to that community spouse so that property stays safe as well. Everything else is countable. IRAs, second property, cash accounts, investment accounts, all bank accounts, it's all considered countable. If you're applying for Medicaid, per applicant, it's $2,000. But if you're married and you're both applying for Medicaid, then it's $3,000 total. Medicaid is going to look at a couple different things. They're going to, if there's a community spouse involved, that community spouse needs to be able to keep a certain amount of money. They're going to look at a snapshot date of when the Medicaid applicant first entered into a facility and did not return home. So they're going to go back to the first of the month. So let's say that the person entered into the facility on September 15th. They're going to go back to September 1 and look at all the assets and then determine what the community spouse resource allowance is from there. The maximum is $128,640. The minimum is a little over $25,000. So it's half of the assets, but it's subject to a ceiling. So if the, we'll get to it in just a second. I'll explain it in a second. These are some other numbers that we won't really go through. Let's see. So here's an example. So if the couple, well, this is actually a little bit low. So let's say that the couple had $100,000 total between the two. It doesn't matter whether it's his, hers, joint, it doesn't matter. They're all considered, it's all pooled together. So if the couple had $100,000, then the community spouse is entitled to keep $50,000. But if the couple had $500,000, it's not half. Remember, there's a ceiling of $128,640. So if they had $500,000, community spouse is only entitled to keep $128,640. So that difference between those two numbers, that's what we want to try to protect for that community spouse. So that's what we're looking at with regard to asset protection. We'll kind of run through some of this a little bit quicker than we usually do. We only have 45 minutes today, so I don't want to get too much into the details. But again, if you guys have questions, let us know. Let's see what's next. Transfer of assets, joint assets. So any transfers between spouses is disregarded. So we don't have to worry about that. But if you're transferring anything to children or to a trust or anything, that's going to be considered an asset or potentially a penalty for gifting purposes. And if it's a joint account, it does not mean that it's protected. So if you have a joint account with your child, it doesn't mean that half of the account is protected. That full value of that account is going to be considered the 100% attributable to the Medicaid applicant. And if you give up control of that account and take your name off and then it just becomes a child's account, that's going to be considered a gift. If you have a prenup in place, it has no effect on Medicaid purposes. So you may go in and with a prenup, get married and say, what's yours is yours, what's mine is mine. Medicaid disregards those, so that's not going to be helpful for Medicaid purposes. Also, waiver of an elective share. That's going to be considered a gift for Medicaid purposes. So if you disinherit your spouse in your will and they don't elect against the will as part of the elective share, that's going to be considered a gift as well. Or we talk about transfers between spouses, so that's going to be disregarded. Transfers to a blind or disabled child also is going to be disregarded, so we don't have to worry about that. We just have to worry about that child and what kind of benefits they're receiving. We don't want to disrupt their benefits. Sometimes people will retain something called a life estate. You may have heard about that. A life estate is just a right to the property for the remainder of your life. So you're still holding on to a piece of it. If you're entitled to any rents, you still get those rents. If you have a property tax freeze, you still will get that. You'll still get your property rebates. Now, there are some rules that go along with that with regard to if the person then is going to go on Medicaid. It's a little bit of outside the scope of what we're talking about today, but we can talk about it later if you have any questions. 2036, we won't get into. That's a tax code provision. We won't really get into that today. That just, when we're talking about a step up in basis, that relates to kind of 2036 and 2038 of the code. So we talked about transferring assets to children, right? That's not something that we want to do. You're transferring your real estate to your child. That's probably not something that we want to do as a direct transfer because of tax issues that we already discussed, because of potential creditor issue, divorce issue, those types of things. So we'd much rather create a trust and transfer that property into the trust because we can control it a little bit more. We can control the outcome. We can control our tax strategies. So it's just a better way to do that. Again, the person can retain a life estate if they want to. It's a right to live at the home. The beneficiary ultimately is going to get a step up in basis. So we won't have to worry about that as well. It's going to avoid that capital gains tax. So the life estate certainly is an option as well. So we're going to skip through this life estate a little bit. So we talked about grantor trust. We talked about trust, right? We talked about all the estate planning documents. We talked about transfers to a disabled child. We're not going to get into an ILET, which is a life insurance trust. We're not going to get into the Medicaid annuities during this presentation, anything of that nature. We only have a few minutes left. There is something called estate recovery in Medicaid, so that if there was an asset that was retained by the Medicaid recipient, then Medicaid is going to have the right to recover. So really the best example I can give you is if there was a home for sale, but the Medicaid applicant otherwise ran out of money, they can get on Medicaid and still own that home while it's still listed for sale. So as an example, let's say the person gets on Medicaid and they're on Medicaid for a year before the house sells, but before the house sells, the person passes away. Now, Medicaid is going to have the right to recover against that house to the extent that they paid out for Medicaid services. So that's what estate recovery is. We can also have an annuity that it can protect assets for the community spouse. So remember, we talked about assets and we talked about income. Assets count, but if we convert those assets to an income stream for the community spouse, now it's no longer countable. Now it's not an asset, but rather it's income, and income is disregarded for the community spouse. So that's one way that we can preserve assets for that community spouse. We talked about some exceptions, disabled child. There's something called a sibling with an equity interest exception, caregiver child exception, although that's very difficult to get through. You have to jump through a lot of hoops with regard to that caregiver child. So there's only a few ways to pay for long-term care, right? You've accumulated enough assets so you can private pay. You have long-term care insurance. If you're a qualifying veteran, VA may help up to a certain amount. Medicare will help a small amount, days 1 through 20. So if you go into the hospital and you have a 3-day hospital stay, and then you go to rehab within 30 days for the same condition or reason that you were in the hospital for, then Medicare will cover for a short period of time in rehab. The first 20 days are paid in full. Days 21 through 100, there is a copay per day by the patient. After day 100, and most people don't get 100 days, there's no coverage through Medicare. And then ultimately, Medicaid is what most people ultimately have to fall back on if they don't have enough assets to pay for their long-term care. Long-term care insurance, some people may have it. I would say most of our clients don't have it just because it either wasn't in their budget or they didn't know enough about it or didn't care for the product. It's currently estimated about 12 million older Americans need long-term care today. That's supposed to go to 27 million by 2050. Some statistics for you. Those individuals who reach age 65, there's a 40% chance that they have to go into a nursing home, and a 70% chance that they're going to require some form of long-term care in the future. So, medical costs are going up, so we have to make sure that we have the ability to pay for those medical costs. We're not going to get into long-term care insurance. Let's skip over that. Here's some challenges that currently seniors are facing. Low interest rates. They don't trust the stock market. It's very volatile. A vast majority of clients rely on Social Security for the majority of their income. Unfavorable job market, rising healthcare costs, massive debt. Student loan debt has jumped up 500% since 2005, and that's not necessarily grandma and grandpa going back to school, but maybe they're co-signing for their grandkids' student loans or something along those lines. In 1992, 25% of persons over the age of 62 had mortgage debt. That jumped to 45% by 2010. And then the last one, very generational, it's about 43% of seniors age 60 plus admit to helping their adult children pay their bills. So there's some challenges there, right? So do we have any questions? We went through a lot today in 45 minutes. I think that's a record. Anything on estate planning, wills, revocable trust, powers of attorney, healthcare POAs, living wills, Medicaid? I know it's a lot to digest, but if you have any questions at all, please feel free to reach out to us. Alzheimer's Association is a great resource. They have a lot of information, a ton of information, constantly in the community, and they've been great to work with. So we appreciate that, Mary Beth.
Chris, thank you so much for your very informative presentation and your time today. We hope you enjoyed hearing Chris Bratton discuss this overview of the 5 most important documents and the importance of having these documents in place. To learn more about the Alzheimer's Association programs, visit alz.org, call the helpline at 24/7 helpline at 1-800-272-3900, and follow this page. And don't forget, our Walk to End Alzheimer's is happening now. Please visit our website and register to walk. Thank you so much for joining us today.